Thank you so much, Dee, for the introduction. I don't think there's a lot that I can say about myself. It's always weird listening to somebody else read your bio at times. But my name, like it's been said and displayed over here, is Tshepo Ricki Kgositau. So you can be able to just use Ricki in the context of the conversation that I would like for us to have more than anything. And rightfully so, I am a person who is a Botswana, firstly to just determine where I'm from. So I come from a small little country that many people do not know. It's called Botswana. We know it now because of a lot of the kind of case law and jurisprudence that's been set in the country. So somebody, I think it was Kutrika yesterday, we were talking, trying to locate where Botswana is on the African map. So if you look at it right at the very bottom tip of the continent, you would find South Africa, which also houses Lesotho and Swaziland. And right above it would be Botswana. So Botswana sits right in the middle of a landlocked position between South Africa, Namibia to its west, and then Mozambique to its east, with Zambia and Zimbabwe into its northern parts. So we share quite a lot of borders with a whole lot of other countries and pretty much landlocked. And I work for an organization called Accountability International, which is an INGO that was founded in Sweden back in 2005. And it was founded within a space and a context within which there was a lack of political will and really engagement around dealing with the scourge of HIV and AIDS at the time. And our founding chairperson, Rodrigo Harai, who is from Chile, but has Swedish citizenship at this point in time, was a child of a migrant himself. So having been present at the then International AIDS Conference that was hosted in Durban, he met up with Nkosi Johnson, who really profoundly shifted his way of thinking around accountable leadership towards marginalized community. For him, it was a heartbreaking experience to see a child who at the time was about 11 years old, having to take up a stage like this one in order to be able to call leaders to attention around the ramifications and the implications of HIV, particularly towards those that were already marginalized for various reasons, thereby speaking to persons that were in rural areas, persons who are economically disenfranchised, a majority of black communities in South Africa and across the continent were affected by HIV. And over the years, Accountability International, which essentially was founded as AIDS Accountability International, has gone through quite a lot of metamorphosis, which came as a result of continuously also seeking ways in which we could not only just focus on the implications of HIV on the life of a particular individual or communities, but also looking at ways in which the intersecting struggles of that particular individual can also be remedied. Because one of the major issues that were also related to persons, or that impacted heavily on persons affected by HIV at the time that we were founded, was issues related to access to drugs, obviously, issues related to access to water and sanitation, issues relating to access to education, where many of these particular individuals who were children at the time were losing parents like that, where essentially there was a whole lot of child-led households, which essentially then brought to the fore a need for AIDS Accountability International then to focus more than just on HIV, but on other health and well-being related issues. And with that, it's how then the program of the organization also grew to looking into other health-related issues and outcomes, but more intently also looking at the intersection of HIV and sexual and reproductive health and rights. And it is why over the past 12 years, the organization essentially also then morphed in terms of the framework that we used to approach the work that we were doing, and looking at ways in which we can also bring marginalization to the fore as a particular framework, as a particular lens that we could be able to use in continuously pushing for not only health outcomes, but human rights related outcomes as well as developmental outcomes. Hence, last year at the International AIDS Conference in Amsterdam, we then relaunched the organization, having gone through a whole entire 2 years of reviewing our strategic vision as an organization, And with that, coming to the realization that the organization has grown to a point where our methodology and framework that we use to hold leaders accountable was one that was being asked of in many other spaces, in other movements, and in other communities that we essentially did not already have partnerships with. But we're limited, obviously, by the confines and the restrictions of the former strategic plan and vision of the organization. With that, then, it's how we have gotten to this point where we still retain the vision of the organization as was originally, with just a bit of a refinement, looking at a vision of a world where there is accountable leadership that permeates all spaces and all spheres of society. And that our mission, we taking ourselves as Accountability International to be a watchdog. Our mission is to essentially ensure that then we amplify the diverse voices of marginalized community by ensuring that the voices of these particular communities that we work with and we serve lead all the interventions, the work, and the program of the organization in and of itself. And with that, we partner with particular movements, with particular communities to continuously use what to us is a participatory action research model, which ensures that then we don't come in to do research as experts, but understanding and acknowledging that communities carry living PhDs on some of these particular issues that we are doing, documenting and researching. And all of the work that we do essentially is documented to ensure that then civil society has tools through which it can be able to hold leaders accountable. So we do research that is community-led research with an intent to support and substantiate advocacy initiatives by various communities and partners that we are partners with. And we do that with an accountability framework of the organization that we just call simply TDA, which is transparency, more especially around data transparency, and continuously seeking particular communities of persons that are not well documented, that are not visibilized. And with that, we encourage that then with evidence, we enter into meaningful dialogue with those that hold particular portfolios of responsibility and of power and of influence as well, to be able to galvanize and support action that is then warranted there on going forward. So like I said, we are an African-led INGO. I am the executive director as of last year, beginning of 2018. And the organization has always and continues to retain a particular focus in the Global South. The essence there being that mostly we understand that communities that are underserved, that are underrepresented, that are further marginalized are from the Global South in the majority. Hence the focus being that we are an African-led organization that has work across Asia Pacific and then Latin America as well as Africa, and that's the breadth of the scope of the work of the organization. So we essentially have always been known to be the scorecarding people, which we've now moved to becoming these accountability people as well, because we've developed quite a lot of breadth of scope of scorecards through which the essence was to be able to give any particular decision and portfolio holder a snapshot of who is doing well and who isn't doing well against particular commitments and according to particular deliverables that are set. And with that, then we are able to continuously then influence policy formulators, legislators, heads of states by immediately pointing to them in a comparative way how they're doing against their own counterparts, which is another very strong tool and avenue to be able to use in continuously pushing for action from our leadership by shaming them. I don't like to say it, but it does have to be done at times. We need to shame our leaders in order for them to be able to be sort of jocked into realizing that there is a lot of action that needs to be taken, and that they're also not faring very well against their own counterparts, because with all these peer review mechanisms that we have within various human rights bodies and collectives, both regionally and globally, there is a peer review process and mechanism through which states are supposed to continuously showcase how they are doing. And we have an office in Stockholm, obviously, where we are registered. We still retain our Swedish registration. And then we also have an office in Brussels. So Stockholm is ideally our administrative office, which makes sure that then we are continuously compliant to Swedish regulations, while we have an office in Brussels, which is sitting right in the heart of the EU, intently so from a fundraising and resource mobilization perspective, to be able to continuously then engage with some of the more strongest of developmental partners. And then there is the Cape Town office, which is where I sit. Maybe going back, the Brussels office is also where our director of research development and resourcing sits. So that's the hub where I often direct most of our interns and other people who want to go through learnerships to be able to work much more closer with her, because she's the person who's also overseeing most of our research work and research deliverables. Then Cape Town is the African base itself, and that is where I sit with some of the senior researchers in the organization who also are project managers of various projects that they are leading. So that's where essentially the actual work of the organization is taking place. And then we have a half office that's opening up in Nairobi at this point in time, which is part and parcel of the new strategic direction of the organization to really widen our footprint into West Africa and into Central Africa. So an office in Nairobi at this point in time was much more ideal, being that we have a communications manager who is from Kenya, who's based in Nairobi. Hence the decision not to relocate them to Cape Town, but just continue maintaining them in their own environment where they have a wide network of partners and contacts that we can be able to tap into. Hence the reason having the zero point 0.5 Nairobi office. Okay. Thank you, Dee. So who am I? I think Dikshita did an amazing job in terms of just introducing who I am. Many people, somebody did ask me yesterday, and I just said to them, okay, they asked me that, like, so you're a lawyer? And I was like, oh Lord, this is going to be a long conversation. So ideally, I'm trained in international relations with a particular speciality in international human rights law and diplomacy. And that was also kind of my way of wanting to be able to tap into my passion for law, but at the same time, wanting to continuously still be able to grow my passion, which was, at the time, the vision was to work for the United Nations. Unbeknownst to me, I would be working now outside of the United Nations space to hold the UN mechanisms and funding mechanisms accountable. And that was the reason, essentially, that I have always been a person who was passionate and continues to be passionate about social justice and social development work. So even from childhood, when I was in primary, I was already engaged in a program that was done by UNICEF called the Girl-Boy Education Movement, through which it was a peer-to-peer kind of support mechanism in schools for students who had issues or challenges at home or individual challenges that then impeded on their learning. And the essence was to be able to continuously be each other's support in a sort of a buddy system. And that is where, for me, the passion for child rights was actually founded. And that is where the fire for me for social justice was actually born. And it is how then I have continuously then engaged in the NGO space since I graduated in 2010. And I then worked for an organization in Botswana called Rainbow Identity Association at the point of having graduated and then returned to Botswana. I kind of returned to Botswana because I had to, because my mother wasn't well. I'm an only girl in the middle of 3 boys who are my brothers. And with that, when my mom fell ill, I had to literally just drop everything in Johannesburg, where I lived for 5 years while I was studying, and then I was already working for another year. So I moved back to Botswana, and that's how then I lended my time to RIA on a voluntary basis, essentially, because I was still at the time trying to look for employment in the country, which I had not necessarily planned for. So in that time, it's how then Rainbow Identity Association, which happens to have been a support group that we founded for trans diverse individuals while I was still in university at the time. So at the point where I was still in varsity, RIA gets registered in 2007. So by the time I graduate, it is now a fully fledged nascent organization that is primarily focused on transgender and intersex persons' rights in the country. And I then started working with them, and that is how then my introduction really into the more formalized advocacy and programming for LGBTI, but more specifically trans and intersex issues and matters and persons was actually founded. And it is that very portfolio itself and the organization that gave me opportunity to be able to then become the regional advocacy coordinator for Gender Dynamics in 2014. And Gender Dynamics is really the founding parent of the continental trans movement on the African continent, because of the kind of exchange and learning exchanges that it offered a lot of activists from around the continent, it was founded around the same time as Accountability International back in 2005. And with that, providing a platform for cross-learning, more especially just of sharing narratives and experiences and lived realities was the way in which it catalyzed the formation of or the emergence of a trans movement across the continent. And I then led the whole entire regional program at the time across Southern Africa, expanding the footprint of the organization beyond just the kind of bilateral arrangements and partnerships that it had with different organizations, but having a fully fledged program that really was clear as to what its regional objective was and the targets thereof, and to be able to measure and monitor our own impact and growth thereof. With all of that work, and when I was at Gender Dynamics, I had an opportunity then in 2016 to become the executive director when my predecessor left at the time. I honestly will tell you, I do not like leadership, but at the time, it really needed to have, the leadership required that the person had a vision for the region, but also experience from the region, which I happened to have been the only person within the team internally who could be able to present themselves forward in that regard. It wasn't handed on a silver platter, however. And while I was at Gender Dynamics, something that was really, really incredible was I had an opportunity to, with the kind of regional oversight that I had, to be able to spot a gap that existed insofar as regional collectivizing and organizing around trans issues and around intersex issues. And it was when, in that time, that in 2014, going into 2015, I catalyzed something called the Southern Africa TransForm, which is a collective of now about 17 organizations that come from 12 countries across Southern Africa. And it is meant to create a platform where, as trans organizations that are trans-focused or trans-led, we can be able to continuously learn from each other's best practices, from our experiences in the programming that we're doing, and with that, creating a very strong basis and foundation on which a regional agenda for the movement, or at least the sub-regional one in the part of Southern Africa TransForm, could actually come to the fore and be actualized. And it catalyzed some other organizations like the West Africa TransForm, which I've been involved in developing a strategic plan alongside with them. And having moved to Accountability International from last year, I still continue to support quite a lot of the work and initiatives of these particular sub-regional entities and bodies with the work that we do, because there's some other elements where there is intersecting priorities between Accountability International and some of the other movements that we work with. Some of that work is around strengthening the capacity of regional movements and organizations to really, really meaningfully engage at sub-regional and continental level to influence policy across the continent in and of itself. We do quite a lot of work with other movements and organizations around accountability literacy, which are trainings that are really targeted at looking at some of either the health, developmental, or human rights commitments and mechanisms and avenues through which we could be able to hold leaders to account on those particular commitments. So I bring with me a passion in litigation. I identified early on in university, in my undergrad, how we as LGBTI persons were vulnerable. At the time where my physical transition actually took place, I was in the heart of being a student representative within the SRC at Monash, which is called the Monash University South Africa Student Association, MUSASA in short. And at the time, I was also the founding member and conductor of our choir in school, and then also a part of our national debating team. And with that, what I realized was that my transition happened right in the heart of student life and in the prying eyes of the whole entire student body. And it was then that I learned more clearly of the kind of vulnerability that we carry in spaces where there aren't any kind of protective provisions that are made to ensure that then even a learning environment is one that is safe for a person like myself, and that I'm also protected should there be any kind of violent experiences that I experienced. So in that time, which was 2007, 2008, there wasn't any kind of anti-bullying, anti-harassment protections for LGBTI persons on campus. It was much more specific towards it was generic, more like to any other person, but with a particular focus on protecting young women on campuses from harassment and violence from men, of which then it meant that we had to also go through this whole entire process with the management of Monash itself to be able to reform our security detail, to making sure that then we were also protected explicitly by the statutes that governed our campus and the whole entire institution itself. And that is where then the passion really for LGBTI specific advocacy, programming, and activism in itself was also founded from that kind of experiential point of view where I was experiencing some sense of harassment from some other individuals who found me to be very fascinating for them. So they had to be dealt with, and that is exactly how all of this as well came to culminate in my being in the LGBTI movement for over 11 years at this point in time. I'm a person who is proudly a trans feminist. I do believe that there's quite a lot of rich experiences that we as trans persons bring that also continuously refresh and invigorate feminist principles and feminist ideals, and continuously bring into the fore the perspectives of a transgender feminine person, and for grounding how we are vulnerable as well, and how patriarchy also permeates spaces where we lead, spaces that we live in, spaces that we work in, spaces that are just even social spaces that we engage on, that we can engage quite a lot on. I do quite a lot of media outreach work, and just as a way of continuously raising visibility around trans persons, around queer issues. I have of recent in this year now added the title columnist to my never-ending CV that is titled, and I self-titled it, Queer Eye, metaphorically speaking to the queer eye that we often receive from greater society that is conforming. But more than anything, offering the reader of this particular column, which is contained in a newspaper, a mainline newspaper in Botswana called the Botswana Gazette, which is a weekly publication and a weekly column that I'm also writing for Queer Eye, that offers the reader something fresher in terms of understanding queer perspectives within just regular things that individuals just take for granted. So that's another avenue in which I'm continuously making sure that then we are able to engage on queer matters and on LGBTI and on trans-specific issues more intently. So I'm going to talk a little bit, well, not even a little bit. Now this is where I get to the talking part about really major things that are important for this conversation. And it is about the journey that we have gone through. I think I shared the judgment that came out of our litigation in 2017 in Botswana, which is just shortly called the ND judgment. And I'm going to be running you through understanding how we actually approached this particular litigation. How we got to the point of being in court in 2017, I would have to send you back to 2011, which is at the point where I'm now relocating back to Botswana. And in that relocation, I happened to have lost a pack that had some of my certificates, particularly my certificates from high school and junior high, as well as my identity card, which I do not need to use when I'm in South Africa because I have to use my passport. So in that time, with that move back from Johannesburg to Gaborone, which was really ill-prepared on my part, I lost a pack that had my ID card in it. But then when you get to Botswana, as a Botswana, you ought to present your ID card, which we call it an omang. So you have to present your omang card in order to be able to access any kind of services and social and public spaces, essentially. So at the point that I get back into the country and I'm applying for different opportunities that I was seeing coming up, I was requested to continuously then attach a copy of my ID card, which then became very problematic because I didn't have one, and I realized very soon getting back into the country that I needed to go and get it replaced. So I went to the Office of Civil and National Registration in 2011 to get my ID replaced. And at the point that I met with this particular individual who was helping me from the front desk, she indicated to me that, did I realize that there's an error on my sex marker, because on her side it was showing male, whereas standing in front of her was this woman, of which I affirmed that yes, I am a woman. Few minutes, she stands up and asks me to just wait for her, and then goes to the back office to speak to the regional registrar who is in charge of that regional office in Gaborone, Gaborone being the capital city of Botswana. And I'm then called a few minutes into the room to speak to this regional person. It was a man called Mr. Disang at the time, whom we had a beautiful chat, him and I. He was really, really a wonderful person who was just really welcoming, and I think he was really courteous to me. And we engaged about the fact that I had undergone this gender affirming process for myself to be able to affirm my gender, which wasn't a surprise to him. And at the time, he indicated that there are such matters that they have dealt with. To him, he was conflating trans and intersex at the time. So I got to understand within the development of that conversation that they had assisted intersex individuals procedurally through the department to be able to get court orders that could then be able to facilitate and necessitate a change of sex marker for intersex individuals. And at the time, he indicated to me that they were no longer permitted to do that process on behalf of any particular clients that came in, and that I had to go and seek a court order on my own in order to be able to get that sex marker, well, to be able to get them to effect the change in essence. So at the time, naive me is thinking, okay, court order, we'll go to court, write an application, get a court order, we then go and actually do this. And I learned very early on, as I approached one of the biggest NGOs, human rights NGOs in Botswana called Bonela, which is the Botswana Network on Ethics, Law, and HIV, indicating to them that I was in need of legal assistance in order to be able to get this process going. And at the time, they indicated to me that no, they would not be able to assist given the fact that they did not at the time have a budget set aside for such kind of matters or such kind of cases. And it was then that I approached the University of Botswana's legal clinic, and I met up with this young woman who happens and still retains the title of being my lawyer in Botswana at this point in time, Lesego Nchunga, who was still doing her final year of her LLB at the time. And we started now probing as to what provisions are there legally to be able to make this kind of a request before our courts and before government. And at the time, we got to realize that there wasn't any clear either prohibition or protections for trans persons specifically in the country. At the time, the legislation was there that then could be able to protect one or provided for one to be able to get certain material changes effected on their identity documents if there's evidence to that effect. And this is contained in our National Registration Act at the time as we were reading it with Lesego. And it is at that point in time that then we really started probing into, okay, what could we be able to craft this request as? Because then sex is one other identifier that is contained within our identity documents, within our OMAN. And as such, at the point, we felt that if there has been a material change insofar as the Section 16 of that Act is concerned, then this is something that we fairly could be able to do easily with all the medical records that we could be able to provide. However, it was in 2011 that Lesego was completing, and somebody else was assigned to my meta who honestly had no clue what she was doing. She just did not get what is it that we were supposed to ask for and how to be able to go about it. So fast forward in that 2011, I'm back into the country and I meet with a friend of mine for his own anonymity, which he has requested and we continue to respect. His name was just recorded as ND, just to be able to protect him. Him and I had been friends prior. We were part of the founding members of Rainbow Identity Association I was speaking to earlier. And with that, then we said to each other, okay, you're looking for the same thing that I'm looking for. Let's walk this journey together then. So it's how him and I really then journeyed together in this whole entire litigation from 2011, which is what then I'm going to also be running you through so that you understand where the Kgositau matter and the ND matter meet and how we have then contributed collectively to attaining the judgment that we now have from 2017. We approached the office of the president in 2011, literally went to the office of the president, met up with one of his permanent secretaries, and the request at the time was that the Department of Civil and National Registration was still refusing to issue us with these ID documents, stating to us that it would be much more contradictory of government to issue us with what it seemed to be fraudulent identity documentation, essentially government aiding criminal activity. So it was premised on that kind of a denial from a very civil process that was being denied to us, that we approached the Office of the President. And the response that came from the Office of the President at the time was that the matters that we are bringing do not have any statutes to regulate them at current. And the encouragement of the Office of the President was for us to approach human rights organizations to support us in taking some cases before court in order to be able to get any kind of remedy. But the Office of the President couldn't be able to assist, which was a major blow. And this is right towards the end of 2011. And in 2012, I was on a platform making a presentation of this sort, similar to this one, in front of the International Commission of Jurists, of which Unity Dao at the time was the commissioner. And I was making a presentation on trans women's access to justice in Botswana, rightfully so, as a person who had been denied access to justice in that regard, or to legal remedy to be able to affirm myself and to attain my full dignity as a person. And in that is where then I met up with Unity Dao, and she was very interested to hear about my case, only to realize that it had not progressed in that whole entire year of 2011. And then she invited me to actually come and meet with her at her law firm, Dao and Associates, in order to be able to just start probing into how she could be able to support me. What she indicated at the time, though, was that she already had 2 matters that she was already now beginning to craft, which related to one, an intersex man, and then one to another transgender person who was a trans man. Only to find out that in 2012, because at the very beginning of the year, she had met up with ND, and we happened to bump into each other at Dow and Associates to find out that we were actually represented by the same exact law firm. So in that time, we now start looking with Dow, we're looking into ways in which we can be able to really craft a very strong case that can be presented before court. And one of the things that was really, really imperative was to ensure that then we have exhausted all internal civil remedies that were available to us, which meant having to go back to the Department of Civil and National Registration in order to go to the highest office within the department itself, which was the director of the department at the time. I think it was Malepang, whom we spoke to. And in that very time, she also then indicated to us that this is a matter that you might not necessarily be able to get through us as a department. However, there is a particular process through which we put other persons, which would mean sex verification testing. So that was my first experience of it, which is the most invasive and degrading experience that anybody can have. When yesterday I was sitting next to Anzio and we were having a conversation looking at the panel, the first panel that was here, and listening to the lived realities of individuals who are in sport and happen to be non-binary themselves or of a sexual and gender diverse nature, I really got emotional because I understand exactly what that entails, from the physical examinations that are done and the hormonal testing that is done, as well as the ultrasounds that we were put through. It is one of the most invasive experiences of my life that to this point I don't think I will ever recover from, which we were put through. And in those verifications, obviously because of the fact that at that point, I had not had gender-affirming surgery as yet, but I had already been on hormonal treatment for some years. The results that came back were a bit ambiguous, but not in a way where you could categorically say that I was born with a differential sexual development, essentially. And it is how then it was just basically then discarded that with the report that was produced, we would not be able to access the internal remedy that is availed intersex persons more than anything. And at that time, it was where then really we started to mount a very strong case before the Attorney Generals that we were going to go and notify. So that is when then in 2015, 2013 and 2014, where the tests were actually done. There would be one that was done by some other doctor, and then you have to wait for some time for another appointment because these were done in a public hospital. So they were not even done all at once. So it was like a recurring experience of continuously being violated by these medical practitioners who were acting on behalf of the state. And in 2015, it's where we notified the Attorney General of our intent to actually now to file these particular cases. And the Attorney General came back to us with And the answering affidavit was absolutely, absolutely late because they notified us, I think that was July of 2015, that they intend to strongly oppose, and this was written down, which for me felt like emotive language of somebody who was holding a certain particular prejudice, but acting on behalf of the state, because I didn't understand why there was an emphasis on we strongly oppose these cases. But then they did not file the replying affidavit up until the November of that year. And this is right towards the very end of the year. So you can imagine the length of time that we have to wait as well for the Attorney General at this point in time. It was only then in November that as they filed the replying affidavit, we then got a sense on the 4th of December that now they have a new strategy. And the strategy was to consolidate ND and ICE cases, which is very weird because the assertions that were made for that request for consolidation was premised on that the matters that we were presenting seemed like it was one person. But how can you believe that this is one person when you have all of our birth records, including our identity documentation that could show you easily the difference in identity card numbers? So it was just one very clear indicator from get-go on how, one, government did not have a case or a leg to stand on, and then two, the strategy was to buy itself time in order to try and construct some sense of response that could be able to oppose the matters that we were bringing before them. And in that regard, in April of 2016, where I think it was ND's matter that was supposed to have been now, it was supposed to be for status hearing at that time, was postponed because then we are having this back and forth. Our Dow and Associates engaging directly with the AGs to try and help them understand and unpack the fact that we were not the same person. One was a man and the other was a woman, and as such, it was very clear to be able to just take a phone call and call Dow and Associates to establish that are these the same person or not. But there was a great insistence on government's part to continue an investigation to try and really prove satisfactorily to itself that we were not the same person, still buying itself time. So ND's matter is now postponed on April to a later time. And only then in the June of that year was the hearing supposed to be in June for this consolidation matter. And we go come June, Attorney General has still not filed its affidavit and its papers. So we have no idea what that hits actually look like. So the consolidation in itself has to be moved forward again. And this is where, for me, I found a malpractice of justice insofar as our courts were concerned in that time, because there was too much of leeway that was given to government where continuously it was disrespecting the time of the courts, which went without any kind of repercussion. And I did not understand how that was. But at the same time, when you also make an analysis, you realize that this was a landmark case that had no local precedence in the country, and as such, anybody who was to set this precedence, I can imagine how intimidated they were to actually sit down to either listen to the matter or to have to go and argue opposing it. So come that year, June, we have not filed anything, and it meant that in February of 2016, when my matter also came up for status hearing, the judge then decided that we're going to have to push the matter forward to June, and this is all in line with keep giving government an opportunity to decipher whether we are the same person or not. And with that, then, it is how the heads had not been filed by June. Only in September of 2016 is where then the consolidation is withdrawn by the AGs. So they decide that, no, we're not going to consolidate the matters. And in so doing, they also filed a motion to abide by the court's decision at the time. So we were like, whoop, whoop. Means once the court says yay, there's no opposition coming from government. And then we move, as we go along, the matters are set now for late 2016. It's in 4th of, I think, the December that year, that then we got a sense of when our matters were meant to be filed, where roll call would be, and then when we essentially were expected to actually argue the matters. So come again in 2017 March, ND's matter is argued in court. Mine was supposed to be in April. Come April, We have the status hearing, and Attorney General, while we are there, and the case number for Kgositau versus the state comes up, and the representation of the Attorney General at the time tore a little paper out of her notebook and literally wrote on it, "I have fresh instructions, we are now opposing." And we're sitting in court. That was the most, yeah, I'm sure everybody can feel it at this point in time. Disappointing would be a very big understatement. It was really gut-wrenching to imagine that somebody would have allowed themselves enough time to have filed their motion to oppose and chose not to, only to do it in court where they just tear a little scrap paper and pass it to my lawyer. With that, the judge once again allowed, which for me was a huge disrespect to Justice Dambe's time and her court, because then this ought to have been filed prior to us sitting in her court to check whether everything has been filed accordingly for us to now set the date for arguments. So we now have to go back in order for government to now go and refile, isn't it? Because initially they were not opposing, of which we did not get any particular replying affidavit to that effect. So we had to go and refile, and the matter was then set again for August, for hearing for August in 2017. Come August 4th, the judge herself is not in her chambers and has not informed anybody, particularly our team, as to her absence on that particular date. So the matter has now been set to another judge who had to just basically deliver a postponement date. So now this is August 4th, we are in Botswana, and we come to court only to find out that the judge is not even in the country. The matter has to be postponed again to the December of 2017, where it was set for the 12th, and that is where then ideally we were able to attain the court order. So tracing you back a little bit, ND's matter is now argued in March. Around May, we get a sense and a whiff that the matter has actually been adjudicated positively, but the judgment was not yet released at that point in time. And in August, my judge is not in court. Peculiar, but it's very clear as to what is happening when you apply a gender lens to it. My case was that of a woman, which was argued by a woman in front of a woman justice. She wanted the men to set precedents in order for her to be able to follow on the judgment that was already, to affirm the judgment that would have been already issued. Now in August, as we come to court for us to now argue, she realizes that the decision is not yet available, so she did not even have access to it herself. Instead of having to just continue with arguing the matter, she chose to be absent from court, which then resulted in us having to postpone the matter again to December. It's only at the end of September that the ND judgment from Justice Ntomiwa is now made available. And with that, we come to court on the 12th, and the judge is still insistent on us now going to hearing and having to then go and argue these matters. But one of the things that for me at the time I could not even agree to was the fact that she wanted every single person who had provided supporting affidavits to my case to actually come and give oral testimony to the affidavits that they had provided, which would have meant that all the medical reports, all the supporting affidavits from my friends, from my family, from my mother, my brothers, people who taught me as my teachers, those that I confer with for spiritual guidance, being my minister in the church who also supported me through my upbringing, would have had to be in court to endure the trauma of having to go and represent themselves orally, verbalizing their own experiences, which was really peculiar because in the ND matter, there was no such kind of ask. What was filed and contained as expert testimonies and evidence was admissible, and it was satisfactory, and it satisfied the court. So for me, it continuously was very clear as to how the woman judge was absolutely crippled by patriarchy within the judiciary in itself to be able to set precedents. Mind you, at the back of your mind, in this 2017, we're still sitting with the highest court in the land in Botswana is the Court of Appeal. And the Court of Appeal does not have any woman representation on it in this particular time. So bear that in mind as to what were the precipitating factors to her hesitance to be able to actually deal with this matter in a much more timeously way, because many a times all I was seeing was the justice herself condoning a disrespect of her time, the time of court, and my time even as the litigant in the whole entire matter. So essentially in 2017 is where we attained the change of the court order itself. Now, come 2018, that is effected onto my birth certificate, on my identity card, as well as on the passport. But then there's also another hurdle that still needs to be crossed, which was the one relating to name change, which is not that, is one that we've already won at this point in time, because then the National Registration Act itself provides that you can be able to add 4 names. You can add as many. If you want to have 21 names, it's okay. But you are not permitted to remove a 4 name or change it on your ID card or on any of your birth records. So I had to then go that extra battle, which ND didn't have to, because with him, his names were all gender neutral names. I had a gendered male middle name that needed to be changed. And with that, it meant that we went through the sex marker change first, which was effected, and only now in 2019, April this year, have I been responded positively, where then the name change was also effected based on the court order we attained in 2017. You can fast forward. And here is the strategy, essentially, when looking at our litigation, specifically to the trans matters. Early on, right from the point where our matters are at Dow and Associates, I'm quite involved heavily in crafting the heads of arguments, both on my case and on ND's case, to ensuring that then both cases were really, really, really strong. And the strategy from get-go was to make sure that then we do not make this a single application, because we were testing our courts and testing the system at this point. So we wanted to have the matter seen by 2 different judges in order to be able to ascertain the kind of response that we would actually get. And already from the get-go, we had premised the case on being one related to a gender marker instead of a sex marker. And that was deliberate on our part, which was the intent to actually conscientize the courts to appreciate more gender identity and gender expression beyond just genitalia of individuals, which is what most of gender recognition policy and law in many other parts is often premised on whether the person has categorically transitioned from male to female or female to male. Ours was about protecting the identity of an individual to express the gender that they feel, and to have the provisions in place that can recognize that particular gender. And then it was also to bring the matters under the National Registration Act and not the Deaths and Deaths, or the Births and Deaths Act. Because the Births and Deaths Act itself there provided that you can only make a change to the sex marker of an individual if there was a wrongful entry at birth. There we didn't want to get into the nitty-gritty, which was going to be very murky waters of trying to prove whether this was actually a wrongful entry on the part of myself and that of ND. Which it was, in essence, when you're looking at even all the evidence that was being given and the presentations of yesterday, when you're looking at this thing that often people say we want to do sex verification, how do you determine somebody's sex? It was only determined on our part using one particular avenue or tool of identifying people's sex or gender, which did not even take into account our individual identity at the time, because we were kids. But we didn't want to get into that one, so we decided to take it with the National Registration Act, which then provided for any material changes can be effected if and when there is evidence to that effect. So that was the way we actually then brought our case looking at that particular statute. And to ensure that in the time that we were leading this litigation, that it did not get conflated with the intent to marry. Because at the point in time, obviously being that Botswana still criminalized consensual adult same-sex sexual contact and activity, we felt we did not want to really murk the cases themselves. So marriage, access, equality asks were not included in there, although at the time, more especially that I met my husband, who was then my boyfriend, in 2014, we wanted to just remove that component of our intent to marry out of our asks of government at the time. And then to oppose the consolidation with everything that we could have, because of the fact that we wanted to make sure that then we have ample opportunity to be able to get much more of a different response from different judges on both matters, such that if one were to not be a success and the other being a success, we had an opportunity, an avenue to still be able to either appeal or to be able to still have that particular positive judgment then assigned to the other. And then it was also to ensure that then we have show of support from my family. One thing I did not tell you is that I was raised a girl from the age of 12 by my family, And all of that was things that my mother had to include in there, my uncles included, my brothers included. A teacher of mine who was one of them still remains like a very wonderful person in my life right now because we also are in the same church. She also provided an affidavit because she picked it up immediately when she started teaching me in Standard 5 in primary. So she also supported with her own affidavit. And that was a way of also trying to showcase the social transitioning that I had already attained, in that in the spaces where I lived in school or in church, there was an affirmation of the girl that I am and an expression of a female gender identity in that essence. And then we had to mount a major media advocacy strategy, which was on my part more than anything because ND, being that he's not an activist, and also because protecting his own family that wasn't so on board about his transition, he chose to remain anonymous. And with that, it meant that I had to become the face to the whole entire litigation, which is why then many people, even in Botswana, think that it was only one matter in 2017 because then they were just months apart. But the essence was that I gave a face to this litigation so that then there was an engagement with us as people and not just looking at us as case numbers. So that was also something that was really, really powerful because it was meant to bring along the rest of society and community with us. D. So the ND Tomiwa case, or judgment as we call it, some people say the ND judgment on Tomiwa being the justice who actually rendered this judgment, is one that is really profound. When you look at page 81 of it, it really foregrounds how gender identity, but more pluralistically, identity is at the core of human dignity in and of itself. That the right and freedom to liberty is not just about physical liberty and freedom, but it's also about even that right to conscience, to determine the self, to be able to identify oneself and to have that identity respected by the state actors and by any other person in society, which is really, really crucial when you're looking at this essence of dignity, which is not necessarily enshrined as a right on our constitution, but essentially the whole entire constitutional framework is around attaining human dignity at its core, which is really incredible because the ND judgment gave us that affirmation that was really, really necessary. And that the right to privacy is not just the privacy of space, but it's also the privacy of your own identities, the privacy of thoughts about the self, about your own body and ways in which you want to use it and ways in which you want to be in it. And as such, privacy is a right that cannot be contravened under any circumstances, not by the state and not by non-state actors, because it is pivotal, also much more in touch and in line with dignity. But more than anything, it was also about the invasiveness that the system requested of any person who wanted to verify whether when we present our identity cards, that was actually ourselves, which meant that you end up having to go into very private and very intimate details about yourself to people who don't know you, who you don't even want them to know you, or to know those very intimate levels of your own personhood. There was also a very strong refusal by, there was a strong point that was raised by the Ntomiwa judgment, which was looking at that the refusal to issue us with these gender marker and ID, sex marker changes on our ID, contravened, one, our right to protection from discrimination, which is section 15 of our constitution, the right from inhumane and degrading treatment, which is section 7 of our constitution, and then freedom of expression, and I think that's section 11 of the Constitution, and the right to equal treatment before the law, which is section 3 of our Constitution. And that this denial in and of itself really contravened these particular constitutionally enshrined and protected rights of individuals, particularly on the part of transgender persons. The right to liberty, as I already spoke to it, I won't go too much into it, and that the judgment in itself also foregrounded or solidified the positionality of the legal framework in Botswana that also relies on international jurisprudence and case law and best practices that exist, which is why then the Ntomiwa judgment was also premised on some of the supporting evidence we brought to the fore, such as the Yogyakarta principles, such as the ICCPR, which is the International Covenant on Civil and Political Rights, and even the Standards of Care, version 7 from the World Professional Association of Trans Health, WPATH, which was really, really at the heart of making a very strong determination about how what we were presenting before the courts was actually just but a part of human diversity, which has often been articulated by all the judgments that have come out on LGBTI-related matters in our court systems. And obviously being able to get that distinction and interrelatedness of sex and gender, in that the state in and of itself, though it in certain parts it's asking for people to identify their sex, often at times it's asking for people's gender, and vice versa. At times where it's asking for people's gender, it's in actual fact asking for sex. So it was also having to also extrapolate for government to realize in and of itself that one of the counter arguments that came from the Attorney General was that the matter we were bringing was one that wasn't regulated by the National Registry because of the fact that the National Registry was asking for a sex marker. So us bringing a matter of gender, how was that related? And it was related insofar as the utility of sex or gender markers in essence, where they're often conflated to mean either you're male, female, intersex, or you're man, woman, non-binary, anything else in between, which essentially is how sex and gender are practicalized on a day-to-day basis. Where somebody's asking for your sex marker, they're essentially just looking to see, are you man or are you woman, and not necessarily that what is in between your legs. And that is what we were able to advance with our litigation in that essence. And then when you apply a gender lens and a feminist lens, some of it I already spoke to, I lament the fact that my own judge who was assigned to my case feared having to set a precedence and rather had to wait and step aside for a man to walk through and make the determination in order for precedence to be set. It is absolutely disappointing to see that an individual given so much power and right to be able to set precedence was still crippled to do that in today's world. And then further to that, it was also just realizing how the system treats men versus women. In my case, there was too many delays, there was too much leeway given for all these delay tactics. Whereas on the Ntumiwa case, which was ND's case, by the end of 2016, when now the matters for consolidation was dealt with and that they were opposing, in March his case was argued. By April, May, his judgment was already ready, while mine was postponed not only from the February of that year to now to June, from June to August, from August all the way to December. It tells you in terms of the depth of how patriarchy and how sexism in itself permeates judiciary and even legislative spaces. And that for me was absolutely, absolutely disappointing to recognize that this woman could have literally set a record which would have sent women in law a step ahead. Funny enough, she's the first woman in our Court of Appeal as of this year. But hey, patriarchy princesses are often put in places just to hold the door for men. So I think that's essentially what she's been appointed to do. And then the question becomes, is litigation the end of it all? Is this the magic pill that then all of a sudden after this ND judgment and attaining the court orders, all of our lives are now onkidori, and they actually aren't? Because when you're looking at the intent from get-go, more especially on my part, I wanted a community-centered approach to the case that foregrounded for the court the fact that I'm not sitting there as an individual asking for this sex marker change, but I was there representing a wider community of transgender persons who are disenfranchised by these particular provisions in the state or how they're implemented. And with that, I already knew at the very beginning of my litigation that the win in court was only but going to be a stage on which to be able to mount much more bigger policy asks and legislative asks of our government. So when you're looking at our health policy in Botswana currently, it does not provide for access to gender-affirming healthcare for transgender persons. It does not afford us as transgender persons reproductive rights and reproductive services, family planning, for instance. HIV prevention, treatment, care are very much denied many a times based on the fact that many service providers are still not necessarily trained to understand gender diversity and sexual diversity. And at the point of service provision, many of us continue to encounter those kind of hurdles. And with that, it meant that this very win in and of itself was only but a launching pad on which to be able to engage with the Ministry of Health to be able to reform and reformulate, if it need be, new policy that really would make sure that then transgender persons do have access to the highest attainable level of health care. The same with our education policy. We have instances in Botswana where trans pupils and learners have been denied access to exam rooms places where we've had to litigate on. One of that litigation was withdrawn because then the school policy was amended to be able to allow any person to wear whatever uniform they're comfortable with. But it tells you to the extent which education policy still is very binary, which then places a lot of trans peoples and learners on the periphery. Our labor and employment policy, we have an amended Employment Act of 2010, which was then able to insert sexual orientation as a protected ground from discrimination in the workspace. But gender is still left as this very broad category of protection, which does not necessarily at that point in time, for us, we don't feel that it really takes into consideration the nuances of gender identity and gender expression. And those are some of the asks that are going to be necessary before our ministers and legislators. Obviously, there's a need for a gender recognition policy. We won the case in 2017. Fast forward, we are in 2019, September. We still don't have any gender recognition policy. I was very much impressed to a degree when I was reading the bill that we have on, that's the Transgender Persons Recognition Bill, isn't it? Where I could see and benchmark certain components of it, although some other elements within our policy reformulation process, because we're working on a policy brief currently to serve our government. We're working to make sure that the gender recognition policy is not premised on a biomedical framework and modeling, which already in other parts like South Africa where I live, there is the Alteration of Sex Description and Sex Status Act 49 of 2003, in which a very strong biomedical requisite is foregrounded, which for me is really problematic and it's not the ideal of what we would want out of gender recognition policy. We want self-identification and self-determination, which the ND judgment, as well as even the LM judgment from June 11th now, are able to affirm that the right to be able to self-determine is enshrined within our constitution implicitly and needs to be respected in that way. And that's what we want our gender recognition policy to be foregrounded on. And then obviously engaging significant other friends, family, allies, that needs to continuously happen. And also then to ensure that then we support champions of change insofar as religious leadership, political leadership, and even traditional leaders in the country, because traditional leaders do hold a very strong sense of influence and power within particular constituencies that they're leading. How much time do I actually still have? Okay. I'm going to try and fast forward because our litigation, as I did speak in Botswana, has been on an incremental approach in that regard. I think, Dixita, can you just move to the next slide? One of the major implications of the judgment or of the case being up in the courts and the media frenzy that then followed me around on 4th of August, my husband and I were meant to get married in Botswana in October of 2017. And because of that media frenzy, which we had tried to protect my family and my then fiance from, he got denied a visa to enter the country without reasons. I don't know if everybody can read this. One of the things that, because he applied for a visa in September of that year, it said, Mr. Beltoni Kanza, we hereby inform you that your application for a visa has been rejected due to the following reasons, : application not successful. What are the reasons for the rejection of this visa? We still don't know to this point. Being a person who loves to litigate, I was saying to my husband that we need to go and sue the state. And at the time, our Western wedding, which was scheduled for December in Cape Town, was coming up, and he was like, no, baby, let's just leave it. Let's postpone this whole entire wedding by a year. So from 2017, we only got to get married through traditional and customary practices only last year in October, because then government blockaded my husband from entering the country. Because at the time, with my sex marker not being amended, the fear on government's part was to set a somewhat of a precedence of allowance for same-sex marriages, which is absolutely, I will not use that word, but yes, you hear me. So there's been quite a lot of, in terms of my experience, engagement with particularly religious leadership, with church leadership, and on my part, that's like a little church uniform that we have at Methodist. I was raised by these Christians who, unlike many other Christians, didn't bash me with the Bible, but they believe to this day that God is purposeful, that when God gave me to them, they were the rightful family to take care of me and to love me. So I was unfortunately not the person who was ostracized by the church, but I continuously remain active in the church to ensure that then we also are visibilizing ourselves in spaces of faith and spaces of worship for that regard. And I also have a calling into ministry, my life, particularly queer ministry, and interpreting biblical text in a much more embracing, in a much more celebratory manner of diversity, because there's too much of non-conventional identities and expressions that are contained within our religious scriptures that are often overlooked. You can move on. So we did manage to get married with this mister, and that was us getting married in December of 2017. So it did happen eventually. And then eventually in Botswana, we did have these customary practices that were done. This is the Mahadi or Lobola negotiations as they're often done. And then in Cape Town, imagine I was in court on the 12th. The 15th, I was supposed to walk down the aisle as a pretty bride. I was pretty, but I was exhausted. But it did happen, so you can move on to the next slide. I think there's quite a lot of engagement at this point in time that I'm having with community, and to continuously just raise consciousness and awareness and respect for the fact that as transgender persons we exist. That's the Botswana Gazette, so that's a little bit of a social media teaser that often comes out when the issue of that week comes out. And I'm also moving it into to connect it to a blog of mine that I have on social media that has been sitting stale for some time. That is my lawyer on the right, Letsego Nchunga, and that's a collective or a subsect of the trans movement specifically in Botswana. Over the years, because of raising all of this awareness, being on radio, on TV, print, and everything, some little accolades have come along the way, some of them being these Feather Awards, which are LGBTI-focused awards in South Africa that honor LGBTI activists and persons, as well as non-LGBTI allies who are doing amazing work in proliferating LGBTI narratives. You can move on. So I won 2 awards in 2017, which was just before the major judgment was to be issued. Now I'm going to take you a little bit on this timeline of our SOGI-related legal matters in Botswana itself. I'll run through it, but bear with me. We had the Gaoleti matter in 1991, which was an inmate who forcibly penetrated another inmate, and at the time, the rape statutes only recognized rape as a rape of a man raping a woman, and as such, he could not be charged with rape until then the reformulation of the penal code in that essence. Fast forward in 95, we had Kanani, which has been the major landmark case that has forever been our hurdle insofar as advancing the protections and the repeal in itself of anti-sodomy or anti-homosexuality legislation in the country. 98, Lekgabibo, which is the Lesbians, Gays, and Bisexuals of Botswana, was founded in the same exact year where government then amended sections 164, 165, and 167 of the Penal Code that then prohibit carnal knowledge against the order of nature for any particular person. At the time, the amendment was made to make the terminology and language gender neutral, because essentially before it was male-focused and male-centric. So the essence was to try and make it as inclusive of everybody, which was also a problem that government presented for itself, because then it meant a statute like that one that criminalizes the whole entire country, because essentially it says if a penis goes into an ear or into a mouth, the statute has been contravened. So it was the redundancy of these kind of statutes that also really resulted in a need and necessity to have it repealed. Kanane appealed his judgment from 95. Kanane was caught in the act, apparently, in the confines and privacy of his own home with another person, and they were charged with contravening the penal provisions 164, 165, and 167, and then he appealed, and he lost the appeal based on the fact that the statutes were very clear. In as much as this was in the confines of his privacy, the contravention still existed insofar as section 164 and 165, because 167 is the one that regulates public versus private morality, or public indecency or versus private decency. So he lost that appeal, but because our president has the prerogative of mercy, he was pardoned, but he got a presidential pardon. So he did not actually get to serve any sentence for this particular conviction. 2005 up until 2015, Lekhabibo is denied registration for about 10 years by a government, premised on the fact that you are a gay organization or an LGBT organization and what you are speaking to contravenes the penal code, and as such, we will not register you. And that was the recurring rhetoric that came from the Department of Civil and National Registration, particularly the subdivision for registration of societies and associations. Fast forward, in 2015, we have the Rannowane judgment, which was then the judgment that then secured Lekhabibo's registration. And with that, we were able to then get the order of court to be able to have Lekhabibo registered. Fast forward, we then had an appeal from government, which was then ultimately lost in the High Court of Appeals in 2016. So you are seeing the timelines essentially. 2016, ND and I are also quite busy. Lekhabibo is also in support of all of this litigation, which we are rallying behind as a whole entire LGBTI community. And the strategy on our part was to start approaching the courts with what we felt were much more digestible or softer asks of them until we built a very strong body of work and precedents that could then make sure that the ultimate judgment of 2019 was in actual fact attainable. So that is the timeline. If I could ask for just an indulgence of two more slides, and then we will definitely, so you can just fast forward a little bit, put it in there. So the journey in itself to hold the government accountable has been one, when we're looking at this, avoiding having to conflate the asks that we brought before court with the ask for marriage, which was very disappointing to see the Kenyan judgment that came out the other day, premising the denial of the petitioners based on the fact that there is an envisaged probability of such individuals going and marrying, which was not even included in the petition in and of itself, of which from the Botswana side, it was absolutely dealt with in the most interesting of ways, because the judgment in itself, or as it was rendered by Justice Liburu when I was sitting in court that day, was that if and when the time comes for Botswana or LGBTI persons to ask for marriage equality, then the courts have their doors open to us to be able to come back to them and be able to ask for that kind of provision to be made available. There's been a lot of precipitating factors, and I think that's one thing I really want to delve onto more especially, which has been on that there's a strong political will at this point in time and vocality of the leadership of today. There's statements that our sitting president currently has given, and he's the fifth in line of all these presidents that we've had who've never spoken about LGBTI rights, except when somebody has stepped out of office, where now they no longer risk their constituency and getting the votes that they want. But we have a sitting president who now speaks about the fact that LGBTI persons continue to also suffer injustices and violations of their rights based on the current status quo with our legal, political, and social structure as a country, which really has affirmed quite a lot the case that we brought before court for decriminalization, because it was about proving that Botswana were ready for this kind of change, because the Kanani matter had indicated that Botswana are not ready to accept homosexuality or LGBTI narratives on a much more mainstream level, of which in the new decrim case, we were able to prove these particular shifts, that there is not only just shifts at social level, but even at political level, that we have a lot of members of parliament who continuously are trying to table motions related to protections for LGBTI persons. Haven't been successful, obviously, because the majority is still very much homophobic, but we have had those kind of shifts, and it really, really pushed our case along. And obviously, there's been a growing sense of LGBTI sensitivity of our courts in Botswana, which really, I think, precipitated the win that we registered this year in 2019.